Welcome once again to part two of the webinar. In this segment, we have a panel discussion where we analyze the guidance for a risk-based approach for legal professionals issued by the Financial Action Task Force. For the panel discussion, I just want to maybe ask the attendees if they are able to, if they can open up the document so that they can follow along with us. Now, the guidance for legal professionals commences with an executive summary which states that the risk-based approach, or the RBA, is central to the effective implementation of FATF recommendations, and it means that competent authorities, supervisors, and legal professionals should identify, assess, and understand the money laundering and terrorist financing risks to which legal professionals are exposed and implement appropriate mitigation measures. What I'm going to do is I'm also going to pull up that guidance and share my screen in a moment for those who might not be able to access it. In the meantime, Dina, can you explain what exactly a risk-based approach entails and maybe provide some examples on how it is implemented within a law firm?
Thank you, Natalie. I believe that I touched on it very lightly in my presentation, but a risk-based approach is central to applying mitigating measures. Okay, so if there's no risk-based approach, then you can't mitigate risk because you have not identified it. It's like putting the cart before the horse. All right. So firstly, you have to identify the risks. So you have to examine your products, your services, if there are any typologies that your FIU has disseminated regarding any trends in relation to attorneys and how they are being misused, or legal professionals on the whole, and how they're being misused for MLTF. You can use those sources. You can also look at credible, reliable sources on the country that you're in, World Bank, IMF reports, in relation to what risks have been identified in your country and how, as a legal professional, you play into that and where your vulnerabilities lie. So after you've identified your risks, you have to identify and apply measures to effectively mitigate the risk. And when we speak about measures to mitigate the risks, we talk about CDD. When there are higher risks, you implement EDD. When there are lower risk, you can implement simplified due diligence. So, for example, if you have a new first-time customer, you have to do the entire gamut of AML CFT requirements as it relates to CDD, right? So name, occupation, as your country dictates. All right, so you could look at the specific laws of your country and see what your country dictates for a first-time customer or a first-time transaction, a first-time client or first-time transaction, where there is an instance where a higher risk might be presented. So, for example, where your client is a politically exposed person, you applied enhanced measures. So if it is getting additional information and documentation as to the nature and purpose of the transaction, as to the identity, sorry, of the client, as to the person's source of funds, which is the funds that are being used for the transactions, or in addition, the source of their wealth, which means the source of their entire net worth. Those are some measures that can be taken in relation to a customer that presents with a higher risk. Then you have to put in place procedures and measures to monitor changes to MLTF risk. So the risk exercise is not a one and done exercise. It's an exercise that happens periodically throughout their relationship with your client, throughout the life of the business. You have to continue assessing risk. So everything should include an assessment of the risk. So for example, if you have a client, they've been a client for 10 years, their identification information expired. You may have to do ongoing due diligence on them, and you get a copy of perhaps their updated identification. But you're not going to go through the entire gamut of CDD obligations because you would have already had that information, or you would have verified that the information has not changed. All right. So that's how you do that. And of course, the risk assessment needs to be documented. You need to have a rationale for doing what you do. So there needs to be documentation. All right. I think I will leave it at that and turn over to Natalie.
Okay, Dina, thank you so very much for that additional information on applying a risk-based approach. So having said all of that, how does an attorney determine if the measures that they have implemented in their firm or office to mitigate risk which you've identified, how do they determine if those measures are sufficient or appropriate?
Okay. Of course, there would be an obligation for in audits, compliance audits. So whether it's internal, external, depends on how the national obligation is framed. There will be an opportunity for an auditor, whether it's an internal person or an external auditor, to independently verify that the measures that are being taken are commensurate with the level of risks that is identified. In addition, uh, I think it also has to do with training because a lot of legal professionals, yes, they have their substantive training in law, but they don't quite understand what performing a risk-based approach entails. And I think it would be wise to engage in training opportunities such as these to get more familiar with the landscape in which you operate and how you could go about addressing those risks. So I would say the audits and training. I don't know if anybody else has any other perspective to offer in relation to the question.
I do. So good morning, everyone. Thank you so much, Natalie, for inviting me to do this presentation. As you speak about the ability of the attorney to identify whether the risk mitigating measures that they have put in place are satisfactory, one way of ensuring that it is to understand the risk that you are guarding against. So that my understanding of the guidance as well is that it breaks down the risk according to country or geography. Where do you find that list? You will also have the client risk, and some transactions are higher risk than others. So there are either automated tools out there that will pre-populate with the country risk, the client risk, and the transaction risk. And so you have to make it a part of your obligation to find out what countries are on the list of high risk countries. What clients, especially now with the different lists that are going out in relation to the sanctions listing, are on that list, and what transactions carry a higher risk. And it is and if you do not have the automated tools, there are Excel tools that can be used, which are pre-populated with the countries, pre-populated with some of the risk in relation to the clients, and pre-populated in terms of some of the transactions. So that is also helpful. Another way as well of trying to mitigate against those risks is kind of understanding exactly what it is that you are required to do, because as Dina indicates that you should have it documented. You should have it documented because remember, it's a risk-based and an accountability framework. So I'm going to share my screen, and this is just something that I borrowed from the Law Society of Ontario. So you're now going to begin to create different types of systems. Let's see, they share different types of systems that will help you to navigate the just a second, please. That will help you to navigate the space. So you talk about the client identification procedures. You document what is it that you need to collect from the clients in terms of client identification and why, the type of identification that is required. Okay, I hope, are you seeing my screen now? Yes. Right. So here, for example, they helped with creating this infographic for their lawyers. So you will see that, for example, here they say delivering legal services, but we know that it is delivering the legal services in those 6 areas. If you are delivering services in those 6 areas, you on your chart that you are creating and template for your office, you would click yes. These are the things that I require. I will require client identification as part of my due diligence process. What do I require from individuals? And you see that you make a little T chart there and you set out what you require from the individuals and also what you require from organizations. And also another high risk activity that we involve in, and in fact, it's the money that they are following. So you're looking as well at, the type of activity, receiving, paying, or transferring funds. Yes, you will need to engage in this activity. And remember that client identification is different from client verification. And so you'll see that especially when they are using third parties, you have to verify right up to that last moment that the funds legitimately belong to the client or are connected to the client. And you'll see that there's a source of funds, there's a monitoring that Dina speaks about, and basically your obligation to withdraw. You would create systems in your office that would tell you what the documents are. You could actually create a template, and I think Emil will go on to point out, for example, that your retainer terms, as an example, would change because you would be alerting the clients to the fact that things have changed in relation to these matters, and these are the things that you are required to do. Stop. Thank you.
Okay, thank you so much for that information, Georgia. That has been very helpful, and I'm sure persons will want to know if the infographic will be shared. Yes, it will be. Now, I want to put another question out there, and this is for either Emil or Georgia, or maybe both. It's always good to get different perspectives. Compliance is something that should be led from the top. If a firm has a leader who does not believe in compliance, it's very difficult to build a strong compliance culture within that firm. So there's a concept that compliance should be led from the top down. You should be, as the leaders in your firm, putting the necessary infrastructure in place to encourage compliance with the regulations. And you should be taking steps to ensure that all the fee earners, as well as members of staff in the office, know what is required of them, and that they basically speak to that compliance culture that you're building within your firm. So Emil and then Georgia, can you tell us what strategies you use to ensure that you have a strong compliance culture within each of your firms?
All right, thank you for that. The first step, well, as managing partner of my firm, and so we are a partnership. And so as partners, certainly when this legislation became enforceable, the first step that we took was to meet, to assess, to understand as a group what the implications were and what the obligations were. So the first, rule of governance by partnership is that you are all equally in charge of the firm, and you therefore all equally need to be on board with what is happening. Because the fact is that in a partnership, one person cannot sit and ensure that everybody else is compliant, right? No attorney can sit and watch another attorney's practice, right? So what has to be done is that you have consensus. So we review the draft policies together. We make sure that we understand the draft policies. We look at the procedures. Within my firm, we have portfolio responsibilities. So we have a partner who is designated to have charge of the compliance portfolio. Separate from other like IT, finance, and that type of thing. So that person is the one who drives the compliance documentation, compliance implementation. So it doesn't necessarily have to be the head of firm who drives it, but they simply have to ensure that they support the person, that there is someone who has that responsibility, and then that person is sufficiently supported and resourced in order to be able to implement and continue that compliance role. We also found it useful to designate a compliance officer within the firm. So from your member of staff, the problem with attorneys, is that you're busy doing law, right? Compliance is not actually your main focus. You're busy providing service to clients and so on, and, billing and collecting for it. So many times, if the firm has the capacity for it, it is useful to have a staff member, and it may not necessarily be someone with exclusive responsibility, meaning that's the only thing they do, but with responsibility for the day-to-day compliance and checking files and ensuring that, once the firm has implemented these policies, that they're being carried out. So that, they can almost have an internal audit function as well, and then report back into the partnership. Yes, so I hope that assists.
Okay, so from my perspective, I think that the AML terrorism TPA compliance regime is unique. It's different from other compliance regimes that we have had to contend with. And the difference is a serious one, is that the sanctions apply to the top. So I think once you communicate that across the board, that the sanctions are biting at the top, and the sanctions are not just monetary sanctions, they are criminal sanctions, I think that's one way of getting everyone's attention. And then on the softer side, you engage in a lot of training and awareness. And at least in the initial stages, as regards these particular transactions, it seems to me that you have to be very involved in the process, so that when it comes on to enforcing, for example, that the transaction should not proceed unless. So you have to have those policies in place and reinforce those policies through training and awareness. I agree with Emil that it is difficult for attorneys, and I'm speaking now for the smaller practitioners. It is difficult for attorneys, particularly small practitioners who do not necessarily have the departments that you will find in the larger firms. Like you have a real estate department, that's all they do. They are in the office on a daily basis and able to say, okay, this person is designated for carrying out or ensuring that the rules are carried through. So in the smaller environments, it would be helpful, as well as Emil says, to have an assistant who is designated to ensure that these policies are carried through, and regular meetings with that person, give that the ultimate responsibility lies with you as the attorney at law. But I can't stress enough the importance of training and awareness. And remember, especially when you have staff changes and there is a specific requirement, certainly in our regulations, and I have no doubt that it comes out of FATF, that you are to ensure that your staff is trained. So it's not just about you, the attorney. You are to ensure that your staff is trained in relation to the regulations themselves and carrying them through, and you are to ensure that your staff are of a quality and of a caliber that they are not themselves susceptible to money laundering. And I think at the end of the day, it really comes down to appreciating the seriousness of what this type of compliance regime brings.
Thank
That's
you
that.
so much for that, Emil and Georgia. I just want to say that I just saw that Shirley Ann Eaton has been able to join us. Welcome, Shirley Ann. If you could just turn your mic on and say a quick hello.
Hello, hello.
Thank you for joining us.
Yes.
Shirley Eaton is a lecturer at the Mona School of Business, as I mentioned before, and an attorney at law. She has many years of practice under her belt. And we are so very grateful to have her here with us among all the other panelists today. While we continue our panel discussion, where we're analyzing the FATF guidance that has been issued for legal professionals and how we put everything into that guidance into effect, we have one question here in the chat. I'm not sure if everyone can see it. I believe it has been directed to hosts and panelists only. I will put this question to Dina Marie. Dina Marie, if you can see the question there. It relates specifically to proliferation financing. One of the attendees has indicated that the Caribbean does not have any arms manufacturers and that we have very little to do with any involvement in terrorism, and yet we bear a significant burden. And on the other hand, they believe that we're not required to do anything in relation to activities that may affect our region, like human trafficking. And so that person's question is whether the Caribbean Financial Action Task Force has any input in choosing how our own regulatory framework is actually furthering law enforcement, or has helped to stop an instance of terrorist financing or proliferation financing. And they also touched a little bit on training. Once you've answered that question, could we have someone in the panel also address the importance of training for staff in law firms as outside of attorneys at law themselves?
Okay, thanks, Natalie. So quite a bit to cover here. So I will start with the question regarding the human trafficking. Now, I know that human trafficking is an issue in the region, and it comes down to the country's assessment of the risk. So countries have a duty to assess their risk, identify, assess, and understand their risk. And it's if it's something that the country has identified, even though it's not specifically covered under the FATF recommendations as terrorist financing or proliferation financing, the assessment of that risk and the mitigating measures put in place in relation to human trafficking will also be assessed under immediate outcome 1. So yes, there is a duty on each country to identify their risk, understand their risk, and put in place mitigating measures. That's the core requirement in relation to risk assessment. Now, human trafficking, I believe, is a predicate offense for money laundering. it's one of the offenses. So I do believe that there is a link between human trafficking and money laundering. So it's not as though countries are not required to do anything about their risk in relation to human trafficking. So, a perfect example of where countries have put in place frameworks to actually meet their needs is in relation to the motor vehicle sector. So, for instance, some countries have identified that motor vehicles, the sale, the buying and selling of motor vehicles in their country has been used to launder money. All right. So that is not covered by the FATF standards. However, countries have implemented their own measures domestically in relation to motor vehicle dealers and salespersons in relation to uh, motor vehicles. So it is the onus of the country to implement um, measures which address their risk. All right. And yes, while the FATF does not test the supervision of motor vehicle dealers, it's something that countries have seen fit to put measures in place for in relation to motor vehicle dealers. And also in relation to money laundering, if there's a suspicion that this transaction is a transaction that flows out of human trafficking, then you have to report it. If there's a suspicion that there's activity in relation to human trafficking and therefore there's money laundering, the uh, legal professionals are required to report. So that I don't agree with the statement that there is nothing that's required in relation to human trafficking. There are systems for reporting. It just is not focused on in the standards as a standalone issue as it is for perhaps money laundering, terrorist financing, and proliferation financing. All right. And also the CFATF does have a risk trends and methods group, which also does research. And there was a paper, I believe, that was submitted to the FATF in relation to motor vehicle dealers, because that was identified as a risk by the Caribbean states that are in the CFATF. It was not onboarded as a DNFBP. However, the CFATF does work in terms of research to identify those trends and identify the methods that are being used for money laundering, terrorist financing, proliferation financing in the Caribbean, and we do engage with the FATF on these issues. So yes. Right. And there was another point about very little involvement in terrorism. Yes, we bear a significant burden. So what I think should be emphasized is that terrorism and terrorist financing are separate issues. While we may not face terrorism to the extent that it is faced in a lot of, let's say, European countries and other countries, the nature of terrorist financing is that it's cross-border. So we have to look at financial flows. So meanwhile, even though there may not be terrorist activity in the country that has been detected, there may be links to countries in relation to the financial inflows and outflows in relation to terrorism and perhaps even proliferation. So that's what we're looking at. So just because we say we don't have terrorism in the Caribbean or it's not an issue of significant concern, it doesn't mean that the Caribbean and the North and Central South America, there is no activity in relation to terrorist financing. All right, so we have to look at it as two separate issues. So yes, so the measures that we have to take in relation to those issues have to be linked to preventing illicit flows. All right, and that's what we need to focus on in the Caribbean. I'm looking at the comment. It's quite long.
Maybe Dina Marie, we could maybe address the rest of that question because it's quite a loaded question. We can address it maybe in the information that we circulate after the session. I'm looking now at the paragraph 17 of the FATF guidance for legal professionals, which indicates that the guidance relates to legal professionals when they carry out certain specific transactions, and Dina Marie would have touched on those before. So the question now for the panel is, should firms that do not engage in those specified activities, such as firms that focus mainly on family law practice or criminal law or personal injury or some other aspect of law, should they also, as a cautionary measure, still implement this FATF guidance? Nick, what do you think?
Thank you very much for that. Well, I think I'm just having a little look at that recommendation. The most important thing is that there is a firm-wide risk assessment, and whatever the firm does or the different types of business that the firm conducts, that its risks are understood within the context of the risk assessment the firm has carried out. So if, for instance, your firm is almost exclusively focused on family law, then the nature of a risk-based approach means that naturally there will be less risk of terrorist financing, proliferation financing, that sort of thing. But there may be higher risks of potentially things like human trafficking, maybe where the source of funds has come from. So the most important thing is that the firm itself carries out a firm-wide risk assessment to understand the nature of the risks that the firm faces, and then puts in place different mitigation measures, such as training, such as enhanced due diligence, other measures that might be necessary to ensure that whatever the specific risks that the firm understands that it can face are addressed properly by the firm, by fee earners, and by everyone involved.
Thank you, Nick. I'm going to move on to section 43 of the guidance, which speaks to the management of client funds. Can you give examples of how an attorney's client's accounts may be used as a vehicle for money laundering? Maybe Dina or Nick could take that one. And then Georgia, can you tell us what are the best practices for safeguarding your client's account to ensure that it's not used as an avenue for money laundering by a client?
Okay, thanks, Natalie. So we have to understand that in terms of the money laundering cycle, the client accounts can be used as a first step in converting cash or the proceeds of crime into something else. So it could be used to permit the access to the financial system. It may be used to hide the ownership of the funds. It may also be used as an essential link between different money laundering techniques, okay? So I think a better explanation of how client accounts can be misused for money laundering is in the Money Laundering and Terrorist Financing Vulnerabilities of Legal Professionals report by the FATF. And they have certain case examples where they have outlined the ways in which clients' accounts can be misused. So I will just highlight a few of the techniques that they've identified. So one of the techniques is transferring funds without providing legal services. So in one case there, a client, well, the client wasn't even a real client. So an employee working in a small law firm in Australia, they received instructions from a person. So the client, in inverted commas, which asked the employee to accept a deposit of a particular sum in Australian dollars and transfer it to a bank account in London for the purchase of machinery. All right, so the details regarding the account in London were provided and the funds were transferred, and the client asked that the money was transferred as soon as possible, but no actual legal work was undertaken. So some of the red flag indicators were that the client was avoiding personal contact. They sent instructions via email. The client was willing to pay fees without the requirement of legal work. And the client was asking for requests to be done in an expedited manner. So those were some of the red flags they identified. They also identified some other techniques. I'm just going to go through one more. Now, these things, it must be noted that these things are not in the usual course of business. So it occurs perhaps more as an exception rather than the norm. So I think where a client asks for the use of the account to further a transaction that has nothing to do with legal fees, I think that's an obvious, or legal services. I think that's an obvious one, right? Another technique that was used was structuring payments. So in this case, a legal professional deliberately structured transactions to avoid reporting thresholds. Okay, so what they would have done was organized for the conveyancing of the purchase of a residential property, and they did it by virtue of trust accounts. They did it by virtue of buying it in the name of somebody else other than the client. And those factors cause red flags to be raised. They also did it by getting mortgages and then paying the mortgages off in quick succession. So some of the indicators in that case was that properties were purchased for family members where there was a lack of contact with the family members without good reason. There was also third-party funding, which is the mortgages that warranted further consideration, and significant private funding, and the transfers were structured so as to avoid threshold requiring reporting requirements. So there's a lot of different ways that the client's account can be misused. And if you're using the client's account in the usual ways, these things won't happen. So as I said, some of these things are obviously suspicious. So you can go ahead and read that particular paper. It's called The Money Laundering and Terrorist Financing Vulnerabilities of Legal Professionals. And that report was disseminated by the FATF in 2013. So it may be a bit outdated because it's over 10 years ago, but I think it still does have some relevant information regarding the vulnerabilities of legal professionals. Thanks, Natalie.
Okay, I'm gonna put just two more questions to our panel, and then I will ask Nick and Naomi to deliver their presentations because I'm mindful of the time and they have another meeting to attend. So I'm going to reload the FATF guidance for legal professionals again, and I'm gonna share my screen. Section 77 of that guidance deals with implementing the risk-based approach and taking note of the fact that implementing it can provide or present rather certain challenges for legal professionals. Georgia, can you tell us what are some of these challenges that attorneys at law may face in their efforts to adopt a risk-based approach, and how can you navigate some of those challenges?
I think the largest challenge for most attorneys at law would be the cost. But I believe that if they appreciate that it's a risk-based approach, then by using, they don't necessarily have to go and find a GRC tool or anything as complicated as that. by putting in, policies and being mindful of policies and using things that don't cost you anything, such as your Excel sheets or and Excel sheets, and also taking advantage, I should say, of webinars such as this. That's the best I can say, because the largest challenge, I think, is cost. I think too that probably there are those attorneys who may feel that this doesn't apply to me. For example, that one whose practice is mainly family law, uh, family law, and you do conveyancing on a one-off basis. The law applies to everyone. All that happens is that you need to be able to assess the risk to your business as well as the risk based on the various clients.
Thank you so much for that, Georgia. And I just want to quickly ask Shirley Ann, now that we have her on, if she can take us through section 101 of the guidance, which deals with a practical starting point for law firms and legal professionals, and the approach that they should take, which is really to enlarge what we've been discussing in full this morning, and then we'll move on to Nick and Naomi's presentation.
Okay. One of the practical starting points, of course, when we're using the risk-based approach, the most important aspect, quite frankly, of whatever we do starts off with knowing who our clients are, what we call our customer due diligence. And importantly, as you know, the ultimate beneficial owner of the client is a company, for example. Who really owns that company? Who's the ultimate beneficial owner? We have to also understand source of funds. In whatever transaction we're doing, what is the source of funds or source of wealth that is being utilized in the transaction? Also, we have to pay attention to things like, what are, why they're asking, why they come to us to do this business? Do they really need us to do this kind of business? And some of the what you call red flags, the address they give you doesn't seem to correspond with where they claim they operate, for example. And so all of these things become very important in determining, is this client bona fide? Is this client, is the work that this client is requiring of me acceptable? I'm comfortable doing it. It's not raising any quote unquote red flags. No, what is interesting is that certainly from the competent authorities' point of view, and they're going to utilize certain approaches, which we also can do as professionals. What is the entity? What sort of entity is this? Secondly, what is the geographic location? Where do they say they are doing business, that sort of thing? The other thing we would also want to be looking at is things like, is it going to be a face-to-face customer? Is it somebody I'm going to see every day? Or is it somebody that I'm going to be doing transactions with online? So, the delivery channels that we're going to use when we dealing with this client. And of course, the whole matter of the transaction types, the important thing is getting that customer information right, being able to determine if the customer is who, or the client is who he or she says he or she is, or it is. Satisfying ourselves as to their source of funds, very important. And you know that with reference to what we call politically exposed persons, and the law sets out for us and the guidance sets out for us for these politically exposed persons. They're usually persons who hold a certain position in our economy, and that we are going to apply what is called enhanced due diligence. Heads of state, heads of government, members of our parliament, those types of individuals, sorry. But importantly, you develop a risk profile. Location, type of occupation or business of the person, their source of funds, are they a PEP? Do I apply enhanced due diligence? And of course, I can use technologies, I can use various ways of actually determining who these people are to satisfy myself.
And thank you so much for taking us through that guidance. The guidance is available, and I would encourage all attorneys to familiarize themselves with the guidance issued by the Financial Action Task Force so that you can get a better understanding of what is required of you and basically how your role as an attorney at law impacts the financial system and the overall assessment of your country. Now, moving